It's now time for you to testify in your medical malpractice trial. After your attorney is finished, the defense lawyer gets up to begin cross-examining you. If you forget something in the middle of being cross-examined, can the defense lawyer take a piece of paper or a document and hand it to you and ask you if that refreshes your memory? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is, yes, he can. Now, here's the scenario. You brought a lawsuit against your doctor claiming that, what? He was careless, and that his carelessness was a cause of your injury, and that your injuries are significant and permanent. Your doctor disputes all those claims. He said, why are you suing me? I did nothing wrong. Then he says, you know what? If I did something wrong, whatever I did didn't cause or contribute to your injuries. And then to make matters even worse and get your blood boiling even more, he said, you know what? If I did something wrong and I caused you harm, your injuries really are not as bad as you claim them to be. And then he says, hey, we're never going to settle this case. We're never going to negotiate. We'll see you at trial. Let a jury decide this case. Okay, so now 2 or 3 years down the road, your case finally gets all the way to trial. So now a jury has been selected, and guess what? Now your attorney calls you up to the witness stand, and he prepares you beforehand, and now you're ready to go. And you remember everything he asks you. He asks you all these open-ended questions. Hey, Mrs. Jones, tell us what happened next. What did you do next? And then what happened? Explain. Tell us more. And now you go ahead and give detailed explanations about everything that you remember happening. But now he's done with your questioning. So it's time for the defense attorney to get up and begin his cross-examination. And you know he's going to come at you really hard. And you know he's going to bombard you with questions left and right at rapid-fire pace. Well, during his questioning, his cross-examination, you forget something. He asks you, hey, Mrs. Jones, what did you complain of on the first visit when you saw my client, the doctor? I don't know. You have a brain freeze. And now he asks you, what did you complain of on the second visit? And you're scratching your head wondering, I don't remember, I'm sorry. And now he's going to ask you a series of questions about something that you recall happening during these visits. And each time you come back and say, I'm sorry, I just don't remember. Now, you might be doing that intentionally because you don't want to give him an answer that you know will hurt your case. On the other hand, you may simply have forgotten. Maybe you're nervous. Maybe you're worried about how he's going to treat you during cross-examination. And you just forgot. You remembered earlier. You remembered when you were preparing for the case. You remembered when you were reviewing your pretrial testimony. You remembered years ago when you told your attorney about this. But now, for some reason, at trial, you just don't remember. Okay, so what's one strategy that a defense attorney can use, or any attorney who's cross-examining a witness who claims they can't answer a question? Well, one strategy is to go ahead and take a document, let's say it's pretrial testimony, that you gave during your question and answer session known as a deposition. And now, the attorney opens up to page 27 and says, Mrs. Jones, do you remember a year ago I got to question you during your pretrial question and answer session known as deposition? Yes. And that was done in your attorney's office, correct? Yes. And your attorney was present, isn't that right? Yes. And I was there, obviously? Yes. And there was a court reporter there to record all of the questions and all of the answers, isn't that right? Yes. And in fact, the court reporter did record all of those questions and answers and then transcribed it in the form of a transcript. Isn't that right? Yes. And you were given a copy of that transcript, isn't that true? Yes. And you were told to go ahead and read it, right? Yes. And you were told that if you had to make corrections, typographical errors, to go ahead and make them on a separate page, correct? Yes. And did you do that? Yes, I did. Terrific. And we have those corrections here, isn't that right? Yes. All right, great. Now, Mrs. Jones, at page 27, I asked you the question about what complaints you made to the doctor on the very first visit. Isn't that true? Yes. And your answer was that you made a complaint of having pain in your left breast. That's what's written here. Isn't that true? Take a look. And now I hand her the document. I show it to her so that she can see what the question was and what answer she gave a year or two earlier. And all I have to do is say, did I read that correctly? Is that what it says? And you didn't make any corrections at the time, correct? When you were given that transcript and now you were asked to review it to see if there are any typographical errors or any other type of errors. You didn't make any changes at that time, correct? And at the time, you knew the answer to the question, isn't that right? Yes. And at that time, when you gave that answer, you knew for certain that that was the answer, isn't that true? Yes. Now, Mrs. Jones, does this refresh your memory that that's what you said a year ago? Okay. And now she's either going to say yes or no. And if she says yes, great, now I can move on. If she says no, again, there are other documents and evidence or other prior testimony that I can now use to try and get her to refresh her memory. So now you might be asking, what happens though if she still continues to deny, if you continue to deny having that refresh your memory? I'm sorry, that doesn't refresh my memory. I don't recall that. Okay, now I use something else. Does that refresh your memory, Mrs. Jones? No, it doesn't. Mrs. Jones, I'm showing you the doctor's office note. Do you see where he wrote under patient complaint, says patient complained of pain in her left breast? Yes. And do you know that this note was written at the time of your visit? I don't know that. Well, I want you to assume that that note was written by the doctor whom you have sued at the time of your visit. Assuming that fact to be true, does that refresh your memory? No, it doesn't. Okay, so now I'll use a different document or piece of evidence to try and get her to refresh her memory. So whether this is intentionally forgetting something so that she doesn't want to give an answer that might hurt her case, or whether it's really she just has a brain freeze, the point is an attorney can go ahead and use any type of document. Could be anything. Could be an audio, could be a video, could be a piece of paper, could be a medical record or prior testimony to go ahead and try and get the witness to refresh her memory. And now once it does or doesn't, I can then move on to the next series of questions. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases, these accident cases, and even these wrongful death cases here in the state of New York. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit but are thinking about bringing a case and have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.